We welcome now Pepper Crutcher, attorney at Balch Bingham. Pepper, good to see you.
Happy to be back.
All right, so I contacted you last week after the Federal Trade Commission issued these, what appears to be a whole new set of rules around non-compete agreements, employee non-compete agreements, essentially banning them at the federal level, which would apply to, of course, every state. Tell the folks first what exactly is a non-compete agreement, and I think in working with you in assisting us with our employee agreements, they come in various forms. They can be somewhat restrictive to extremely restrictive.
Yes, and the new rule that will go into effect 120 days after publication in the Federal Register, which hasn't happened yet. So, for example, 120 days from tomorrow would be August 31st.
Okay.
That new rule bans everything that functions like a non-compete agreement, regardless of what you call it. You might call it a non-solicitation agreement. You might call it a training reimbursement agreement. If it effectively disincentivizes employees to switch employers, it's a banned non-compete.
Okay, interesting. That's one way to, I guess, frame it. If it disincentivizes, dissuades. Training reimbursement agreements, you helped us with that. That was common in my industry.
People who were shocked at the rule were most shocked at some aspects of it, and that's one of them.
Yeah, and the deal there is you invest significant dollars in upskilling your staff, training them. And in our case, it could be new certifications, new technologies, constant. I mean, I felt like I put a whole bunch of people through college thinking about the amount of money we spent on all that. And the agreement simply said, okay, after you receive this training, and a lot of times you receive some sort of certification or some credentials as a result of that, something of value and asset that's now in demand from your competitors, within a certain period of time after you receive that, we may prorate a reimbursement of that should you separate your employment from us.
Right.
And they're saying, no, you can't do that either.
What they're saying is if they investigate and since it has a non-competitive purpose, that is to dissuade people from leaving you, then they will call that a functional non-compete.
Liz Warren, the senator from the Bay State of Massachusetts, says that she applauds this move, of course, by the Biden administration, says that pay will increase by $2 billion a year to those who she claims are currently restricted by a non-compete agreement, stuck in a job that they could leave were it not for the non-compete agreement for new employment, and increase their pay aggregately, all these people in Massachusetts, by $2 billion in Massachusetts. Does that sound crazy to you? It does to me.
It's like trying to predict the weather next year across the whole continent. There will be a wide range of results, assuming the rule actually goes into effect.
Okay.
There will be a wide range of results. Some people will do very well. For some people, it'll be like the day that college sports started NIL. You'll be bargaining for an increase in your salary and threatening to jump ship and taking the better offer. For some people whose functions depend on access to trade secrets, for example, they may no longer have access to trade secrets because theirs are now going to be very limited, and their value to the employer may go way down.
That's a good point. Yeah, I hadn't thought about that. So you make a point that you shared with me. Compensation costs might rise if compliance is chosen versus express noncompliance. Unwrap that for me.
So if you have, especially if you're an employer of highly paid, highly skilled people, and they can jump ship easily and take customer, client, patient relationships with them, you're probably going to be willing to pay more to keep them from doing that, right?
I got you. Okay.
That's
makes sense. Yeah. So, you always share with me that depending on the jurisdiction, which could be a court district, depending on where there may be some litigation concerning non-compete agreements, or the state in general, that some are just more employee-friendly than others, and some are more employer-friendly than others.
Believe it or not, state California is very libertarian on this issue. You can't have a non-compete in California.
Right.
That's worth speaking of. But there are other states, Oklahoma, I think, North Dakota, that banned them too. A couple of Republican senators came out in favor of the proposed rule back in January. So it's not just a move on the left. It's some of my professional colleagues and personal and political friends think that the FTC rule is directionally appropriate. Now, they have great concerns about whether the FTC has authority to do it, whether this should be really an issue left to the states, but they think that directionally this is a correct move.
Okay, so in some of the data you sent me, you sort of categorize this as in terms of your clients who would be employers, you want to fully comply or partially comply or not comply whatsoever, and here's kind of what to consider in that. Explain that.
Well, the trigger is going to be the 120-day deadline for compliance after the rule is published in the Federal Register. Now, I don't think it'll be published tomorrow, but let's assume it's published tomorrow. That compliance deadline will be August 31. As of August 31, you've got to send notices to people who might be bound by your non-competes that they're not bound anymore and they're unenforceable as a matter of law and you won't enforce them. You've got to do nothing to enforce new claims that arise on or after the effective date, except with senior executives who are signed up to a non-compete that was in existence prior to the effective date. Okay, so it's that 120 date is a hard deadline. What do you do by that deadline? Do you comply completely? Do you send those notices? If you send those notices, you have probably waived any right you might have had to sue those people on claims that were valid as of the effective date. But you sent the notices to try to be in compliance, and then later the Supreme Court says this whole rule is junk and throws it out. Well, you have now waived your right to file those claims. And we probably won't have a Supreme Court decision until June of 2026.
Wow.
The things that could happen earlier are, say, a Republican gets elected and rescinds the rule, but that wouldn't happen on day one. That would take months to do. You might have FTC majority change and withdraw or modify the rule. Other things can happen other than judicial blockage. But it could go the other way, too. You could have a Fifth Circuit panel, because the pending cases challenging the rule are in the Fifth Circuit, Mississippi, Louisiana, Texas. You could have a Fifth Circuit panel that's very much favorable to the rule. They could say, no, we're reversing the lower court's injunction. It could go up to the Supreme Court with nothing in place to stop the FTC from enforcing it during litigation. That could happen. So if you're gonna elect not to comply, you got to count that risk. And here's what the risk is worth. If the FTC is allowed to enforce it against you, you could be facing fines as high as $51,744 per each violation, and the FTC has reserved its right to call each day a separate violation. That's almost $19 million a year.
My gosh.
You could be facing if you're the one the FTC picks to go after.
Okay, so thinking through our work together when we had the business and you advised us on these matters, we didn't have what was considered just a strict non-compete agreement. You advised us to consider the approach of just having a confidentiality agreement, essentially. Because our concern wasn't, hey, you don't want to work here anymore, you want to go work somewhere else, that's fine. If somebody else has come after you, made an offer, you accepted it. But we sought to protect our interest, our assets, information usually, and could be trade secrets, proprietary information. We don't want you to go somewhere else and use it against us. So would that be a disincentive? How are they going to figure that out?
Well, the publication that's going to be published in the Federal Register, which is now available on the FTC website, ftc.gov, is 570 pages long. Only the last 7 pages are the actual rule. The first 563 pages tell you what the rule means and why they did it. And in that long preamble, one of the things they say is, well, we are not going to go after agreements that simply protect your trade secrets.
Okay.
So, for example, you have a trade secret non-disclosure agreement, and it really only applies to trade secrets, and it really only lets you recover for your real losses that the law entitled you to recover.
Yeah.
That's okay. But let's say you had a trade secret agreement that allowed you to collect $1 million in liquidated damages if you caught somebody taking a file folder with them that had some of your trade secrets in it. That might be a functional non-compete.
That's unbelievable.
Yeah.
So I don't have, as an employer, the right to protect
They would say
knowledge you gain from being employed.
Yes, they would say you do, but we're not going to let you disguise an NDA as an NDA with something that's really functional non-compete.
Because that's really the only, in my view, the only thing we really needed. Because if somebody want to come after one of my people and just say, I'll triple your salary to come work here, well, they're not going to do that if they're not going to bring their information with them.
Right. The fundamental problem is head knowledge.
Yeah, totally. If you can stick around, we'll get into this some more. We got Pepper Crutcher, attorney at Balch Bingham, discussing these new rules about non-compete agreements. It's such a relevant topic to my business experience, and then, of course, working with you, advising us on these matters. But you bring up a great point that you've got companies that have built relationships with customers. Those relationships maintained by their team. And, of course, you got to take care of your people to make sure they take care of your customers. That's kind of the circle that makes everything work and makes these companies valuable. If someone comes knocking on your door and wants to buy your company, in those kinds of situations, they're really buying your team.
Right.
That's essentially what they're buying.
Right.
Unless you got something proprietary where if everybody walked out of the door today, I still got this proprietary, whatever it could be. I told you, the formula for Coke was my example. You got the formula for Coke, I got it. Everybody leaves, I can go hire me a bunch of other people. I still got the formula. But in a services-oriented business in particular, which a lot of small, mid-sized businesses are today, and they're positioning themselves for acquisition, if the acquirer believes that they can't maintain the team, they're not interested. And a lot of times their confidence in that is increased by the fact that they've got non-compete agreements in place.
Yeah, so now let's go to the new world that FTC wants to create, where none of those agreements is enforceable. In fact, the seller employer has had to tell everybody we won't enforce them because it's illegal to enforce them. Is that buyer even going to knock on the seller's door? No, he won't. He'll go hire the 5 top members of their team and pay the seller nothing, and you've wiped out the generational wealth. That business may have been in business since 1922, and the family's depending on that as family wealth, and it's gone. This rule could literally wipe out trillions of generational wealth in small business in America.
And you made the comment, tell the folks here about what Congress knows about this.
Nothing.
Yeah.
Maybe there are a few small family business people in Congress, but they don't predominate.
Yeah, I would agree. Most of them have been there so dang long and been removed from these dynamics, these scenarios, these settings. They're just not aware. But that is the real world out there.
Yeah, and I don't know if you've run across this, but it is tremendously expensive to enforce trade secrets rights in the normal way provided by statute. It's much cheaper to enforce a non-compete agreement. I really feel sorry for small employers who have a great idea that's proprietary, it's a trade secret, and they now won't be able to enforce it because they can't use a non-compete and they can't afford to use the regular trade secret process.
Okay, I didn't know that. So that makes total sense. So, man, absent those protections, so then, of course, you start thinking about, well, how willing would people be to take risk to create essentially new innovations that are going to be trade secrets, certainly when they're in development, before they are monetized and commercially available? That would seem to enter into such decisions. And then the investment community says, well, I'm not going to invest in that. We got no way to protect it.
Yeah. So you may see all that innovation that's being done at mom and pop levels now being done at giant corporations or otherwise not done.
But there is, of course, you lawyers always tell me you got to apply the reasonableness test to virtually anything, right? So, I mean, you could see where a strict non-compete agreement for certain categories of workers is inappropriate.
Oh, absolutely. And states are all over the lot here. Some are absolute prohibition. Some are rule of reason. But I can tell you, practically speaking, nobody is trying to enforce non-compete agreements against the guy who's slicing your pizzas anymore.
Yeah.
Even if they signed them, nobody's trying to enforce those because they know courts aren't buying it.
Yeah.
Right. So the only agreements that are getting enforced are, frankly, a cheap, fast way to enforce trade secrets concerns. That's what's getting enforced these days.
It feels like, however, the Biden administration, some members of Congress, generally speaking in that same party, and just other bureaucrats in Washington do believe that's the case, that there are folks out there slicing pizza that got these highly restrictive non-compete agreements. They could go work for the pizza shop across town making double the money.
If you read that 563-page preamble to the rules, you will probably find 30 to 40 pages of those stories. There are over 26,000 comments sent in for and against the rule, and a lot of the pro comments are from people who say, I had this non-compete, this is my ridiculous little job, and they threatened to sue me if I went to work for a competitor. You know, the pizza slicer kind of thing, the delivery driver, people who should not have any worry, but the complaint that the FTC cites is, well, how do they know it won't be enforced against them? Just having to defend the lawsuit might ruin them financially, and that's unfair.
Right. Okay. But, I mean, you've been to court on involving cases involving non-compete agreements. You did one on us.
Well, we have to work both sides of the street.
Yeah.
Sometime I'm representing the new employer who wants their new employee to beat the rap. Sometime I'm representing the former employer who wants to enforce the agreement.
Yeah.
And often I'm doing both kinds of cases at the same time.
Unbelievable. But I just get the feeling that if such a case, let's take the pizza slicer for lack of another example, if that got to court, I can't see how the court would be favorable to the employer in that situation.
No. So what you're betting on, if you're actually trying to enforce one of those, is you can make the employee roll over and give you something, and you're not so much doing it because of that employee, right? You're trying to you're in the business it's called heads on the wall, like a trophy room and a hunting lodge. You're trying to put the heads on the wall so other people won't try the same thing.
Well,
you're not worried about the pizza slicer. You're worried about the guy who knows the recipe for the dough.
We heard that in our case.
Yeah.
We had a case involving a competitor, and I believe in deposition that it was stated, right?
That's exactly what he said.
I'm trying to set an example here and let people know I'm serious about my non-compete agreement.
Yes.
So nobody else will think about doing this. They'll know that if they do, I'm coming at them. I'm going to sue them.
Right.
Wasn't that what?
Yes, and that's why most employers, if they file those cases against the pizza slicer, will quickly settle them for, okay, I won't work for you for 3 months or 6 months work. So they can say, I got a judgment. I sued him and I got a judgment. So, I'll sue you too.
Yeah. And then there's, of course, there's some sort of reasonableness test, right, on just the geographic restrictions and the term of those agreements, things like that.
Even in relatively friendly states like Mississippi, it's got to be for a reasonable term that's specifically defined, and it's got to be for a reasonable scope.
Yeah.
If your business isn't national, you can't have a national restriction, right? So reasonable geographic area, reasonable time. You got to have a reasonable interest for enforcing it. If your interest is only, I don't want people competing with me, no, that's not going to work.
Yeah. Okay. Well, you have a theory about where this is going at this point?
I think it will be enjoined in one of the two cases that have already been filed, and I would bet the Chamber of Commerce case in the Eastern District of Texas will be first on the injunction because briefing in that case ends June 19th, and I expect we'll have a decision by late July. And then you'll have an appeal to the Fifth Circuit Court of Appeals, and how that comes out may depend on which panel of 3 judges is randomly assigned. Whichever way it goes, you may have a en banc review by the entire Fifth Circuit, and then after that, it'll go up to the U.S. Supreme Court.
What about these new overtime rules? You digging into that yet?
Yes, and this is the first time that the raise has been so extreme that you will probably actually have significant lawsuits making the argument that only academics have really effectively made earlier, which is, where in the Fair Labor Standards Act did Congress give the agency authority to define who's an exempt executive, administrative, or professional according to their salary? You read the text of the law, and it talks about their job duties. There's nothing in there about the salary.
Okay.
Now, a lot of lower courts have approved such regulations in the past, but the outcome might be different this time because the raise is so big this time.
Explain. It went from what to what? 50s?
51.76.6.
That's what I remember, yeah.
Annual salary.
Yep.
So, it used to be you might have an assistant manager who really was in charge 8 hours a day of your store. You're not going to pay them over $50,000 a year to be an assistant manager at a dollar store. They're no longer going to be exempt. You're going to have to pay them overtime.
Unbelievable.
So the question employers are having to face is, okay, do I want to raise these people this much to not pay them overtime, or do I want to pay them overtime?
And does that overtime have to be time and a half? Does it stipulate that?
Minimum time. Well, that rule hasn't changed. It's time and overtime. It's time and a half, with some exceptions.
Still based on a 40-hour week?
Yes.
But if Bernie Sanders has his way, it'd be based on 32 hours, right?
Bernie's not going to get his way on that.
Always good to see you. Appreciate your insights and your expertise, Prepper. Thanks. We're coming right back, folks. Half an hour left.